CAL's and every other library policy in Arkansas that I'm familiar with right now, if a person wants to have a book or any other item removed, and they don't agree with the decision of the staff of the library, they appeal that to the library board. Under Act 372, instead of the library board, the appeal authority is the local government body. So for CAL's, that would be the Little Rock City Board. Part of the constitutional problem I see as well with this is that while the librarians have to document why they think a material is inappropriate or not, the city board just gives a thumbs up. So you end up with government bodies regulating speech without ever giving a reason. So we don't know if they're doing that for legitimate reasons in the First Amendment or not. They don't have to create any sort of record. I think Act 372 has a real problem under the due process clause for that reason. That's the basic outline of what I think CAL's needs to get clarity on to make sure we understand what parts of it are constitutional and what parts CAL's needs to comply with. We've been talking to a lot of other people that have presented themselves as wanting to be involved in this. And I started drafting a complaint, which has been developing as more people have gotten involved. So right now we have something like 16 parties who would like to join with CAL's in challenging the constitutionality of those two parts of Act 372. Besides CAL's, in terms of library systems, the Fayetteville Public Library and the Eureka Springs Carnegie Public Library's boards have both voted unanimously to join in this suit. CAL's files it. Individual librarians, Nate and Adam Webb from Garland County, have agreed to appear in their personal capacities as well. There are two groups that advocate for librarians and library patrons in Arkansas that have wanted to step forward and take part in clarifying this law as well. Those are the Arkansas Library Association and the Advocates for All Arkansas Libraries. Because the first part of the statute, the criminal part, while it's in a bill about libraries, applies to anyone that deals in the kind of materials that libraries do. Wordsworth books and Pearl's books in Fayetteville also want to be a part of this lawsuit to challenge the constitutionality of Act 372. There's also then a group of nonprofit trade group advocacy organizations that all have an interest in vindicating the First Amendment, and they have come in as a group and would also like to be a part of this lawsuit. Those groups are the American Booksellers Association, the Association of American Publishers, the Authors Guild, the Comic Book Legal Defense Fund, and the Freedom to Read Foundation. And finally, as you saw in my memo, we have some brave CAL's patrons who feel that this law would adversely affect their ability to peruse and check out books here and buy books from Wordsworth and generally exercise their First Amendment rights. One of those is Olivia Farrell. She's asked to be appointed on the case, and a 17-year-old Central High student named Hayden Kirby will be represented by her mother, Jane Kirby. There are other folks wanting to be involved. I had hoped to have a draft complaint ready to show you today and file tomorrow, but because of the interest in the case and trying to make sure we get the facts right about the constitutional harms that we think the law is working right now, I'm not quite ready to circulate that to the board, but the substantive legal claims are precisely what's in the memo. You have everything you need to approve a lawsuit there. Those are the core allegations that CAL would make, set out in that memo. So we would hope to file it next week if you give us approval to do that. So with that, I can entertain some questions.
John, what do you want this board to do?
I want you to